Bonjour à toutes et à tous. Hello, everyone. Welcome to the virtual edition of We Robot 2020, the premier international conference on the law and policy relating to robotics, hosted this year by the University of Ottawa Centre for Law, Technology and Society. Reinvented in the times of COVID-19, We Robot 2020 is presented with the generous support of Microsoft, CIFAR, X, and Intel, as well as the University of Ottawa, the University of Washington Technology Policy Lab, and Miami Law. For those who are not familiar with the We Robot format, please note that the authors do not present their own work. Instead, session discussants read the author's papers in advance of the conference and present the author's work to the audience while offering constructive thoughts for improvement and seeding the conversation that follows. Authors then have 5 minutes to respond to discussants' feedback. Then the session usually opens to the floor. For the virtual edition, we invite the audience to rather engage with the papers in the comment section below the video. For this session, we are delighted to welcome as discussant Professor Anne Bartow, a professor of law at the University of New Hampshire, to present 4 papers on discussing legal liability and accountability. First, a paper by Adam Hill from UC Berkeley, titled A Law and Economics Approach, Regulatory Accountability for Intelligent and Automated Systems, Coordinating Multiple Governance Mechanisms. Then Silvia De Conca from University of Tilburg, a paper titled Bridging the Liability Gap Using Human-Centered Legal Design, 3 scenarios to apply the liability from social contact. A third paper, authored by K.S. Park from Korea University with Gabriel Lima, Mian Cha, and Cheon Jeon, titled Explaining the Punishment/Liability Gap of AI and Robots. And finally, a paper from Cynthia Ko from the University of Ottawa, titled Missing the Unintended Forest Despite the Deliberately Planted Trees, Reasonable Foreseeability and Legal Recognition of Platform Algorithm, Facilitated Emergent Systemic Harm to Marginalized Communities. The link to all those papers are available under the video and on our website. Without further ado, I will hand it over to our discussant to give her remarks. Thank you very much.
Hi, thank you for listening. So the interesting thing that brings these 4 papers together, and I have to compliment the organizers of this conference because this is a beautiful panel of 4 papers that really do fit very well together. I teach torts, and I'm at this very moment rethinking torts. So for those reasons alone, I really enjoyed reading these papers. I say that at the outset because I don't have a whole lot of time to talk to you, and I'm not going to waste a lot of time on compliments. This is it. I'm going to mostly go for things I think that need addressing because I think that might be more useful to the authors, but that's not because there aren't a ton of really good things to say about these papers. Very well written, great, interesting ideas, just fabulous work. So torts, the framework of torts can be explained in different ways. Finding justice would be one sort of macro way of explaining. You're looking for justice for people who got injured, and then you kind of have to fine tune it. What if it's partly their fault? And then if you decide you want to compensate them, how much is a broken arm worth? You make all these kind of weird judgment calls. And then as when you bring robotics, AI, robotics, etc., automation into it, everything gets complicated. Now, I've been teaching a long time. I've been teaching for 25 years. I graduated law school 30 years ago, way of saying I'm old. So I've kind of been there and done that. And I lived through the law of the horse cyberspace wars. And just a quick encapsulation, the idea of the debate about the law of the horse was really, is there a law of the internet or a law about cyberspace? Because some people thought there was something unique there that deserved its own class, courses taught, and also deserved its own be a subject area. And then other people said no, that basically this adds some new questions to completely pre-existing law. In other words, we already have property law. Now we're going to, think about property in cyberspace, or, trademarks. We know trademarks in real space, so now we just have to think what changes or is different or is new about trademarks or copyright in cyberspace, so that the pre-existing subject areas would have to absorb the cyberspace. I think that right now that same debate is sort of happening with robotics. That is robot law something unique, or are there already do we already have the tools to kind of integrate them? So that's sort of the way that I'm approaching this, is some of those questions. And the law of the horse stuff is really a classic debate if you have a chance to go back and look at it. So starting with Adam's paper, Adam takes a law and economics approach, and he is very focused on sort of framing the issues and framing the debate. And, ultimately so that law and economics, a law and economics approach toward regulating accountability. And he discusses needing collaborative multiple governance systems, and why do we need them? For the right regulatory mix, the problem with the failure. So when he talks about what's really important in terms of information and having information, and that there's a failure to update information sometimes, and this can be solved if you figure out how to have self-generation of information that's constantly giving a feedback about context, incentives, preferences, etc. And he gives a couple examples, one involving friending and another one involving ride shares. So it's a fascinating article. I am going to say, though, I'm not huge on law and economics. I mean, I do read some of it. I certainly benefit and learn from some of it. But there's a lot of jargon in this paper, and not all of it was familiar to me, so that got in the way of me sort of absorbing what was going on in the paper. So my kind of overarching critique would be too much jargon, or ironically, because you're calling for framing your jargon a little bit, and more illustration. I mean, I know you gave some examples, but illustrating what you're talking about and using maybe less like law and economics kind of buzzwords, I think would sort of strengthen your approach. So that's my critique for you. And I may get back for some more. Now I'm going to talk about Sylvia's paper, which is really fascinating. And she specifically talks about torts. And her paper is about what she calls human-centered legal design. And I'm not sure I've ever seen that expression exactly. I've seen a little bit with the concept, but I love it. Human-centered legal design, I think, is a great way to articulate it. So whether you came up with it or just adopted it, I love those words. And basically, the idea is to figure out how to help solve or close liability gaps from autonomous agents. And she basically rests her analysis on the duty of care and what she calls the qualified social contract. And a couple of examples. She talks about this stuff going on in certain countries within the EU. She gives one example of the doctor-patient relationship. It's a very rich paper. I just want to focus on the duty of care and qualified social contract aspects, because the duty of care is such a fascinating part of torts, right? Who has a duty and why, and the scope of the duty, how to enforce the duty. All those questions, when you put into the context of robots, are just fascinating. They become really fascinating questions. So it's a little, because obviously I teach the United States, I teach torts in the United States, and I don't know enough about international the law of torts in other places. So I don't know. I don't think it's probably fair to ask you to make it easier for Americans to understand. That's like kind of pathetic, really. But maybe I'm going to say that talking about the duty of care and maybe doing some comparative duty of care discussion, I think certainly would help me as the reader. But again, other readers may probably know a lot more about it than me, so maybe not need that help. So I guess at the end of the day, the question is, who's your target audience? Because if your target audience is me, I need more help. But if it's other people in Europe who are going to be familiar with what you're talking about, then it's fine. And the idea of the qualified social contract too, again, the different ways that we talk about the social contract, and really, you might even talk even more expressly about, torts law generally, kind of all about the social contract or not, or lack of, right? What we do when it fails. you know, the government's gonna step up, if insurance system, social safety net, all those questions, and then how that plays out when we're dealing with autonomous agents is fascinating. I just had one remark, which is I know very silly, but you use the word seminal, and I'm on a project to convince everyone to substitute germinal for seminal. So that's just a completely petty point. But I like the paper a lot. So I got to move right along here. Okay, the Park paper, Park paper et al. It's a great paper. It's a lot of co-authors. So. Okay, so this talks about the punishment liability gap with AI and robots, and it looks at some work that's being done or considered at least by the EU Parliament in terms of, a debate about potentially having a new legal status for robots, right? That there's different movements in that direction to have a new legal status for robots. That's, I think from the very first Robot conference, people were talking about that, which is why this is such a great conference and so forward thinking. But it raises interesting questions, and I guess the EU Parliament is at least, potentially saying about, tort law, that integration of robotics and the law of robots isn't going to easily integrate into tort law, that they need to affirmatively tease out what's not working and have a new legal status, I assume, mostly for things like liability, although, certainly propertization or other things might be as well. And the paper asked questions about punishing for wrongdoing AI or robots, and contrast that with the current approach, which is described as the people that we would be sort of on the hook, maybe civilly, possibly criminally, would be the owner, the user, and or the manufacturer, right? Bad manufacturing or bad care by the owner, or user error or user malfeasance. And there's a discussion of the concept of electronic legal personhood, which is pretty fascinating, actually. The obvious objections, I think, that had come up when this issue is raised is, they're really not independent actors. And, excuse me, they generally don't have assets, right? We don't usually have technology they can own things. Although, I know not everyone in the audience is a lawyer, but many of us are lawyers. So when we say that technology can't own assets, well, I think we could find a way, and maybe we already have. So I would take that as a challenge, but I think it's actually a challenge that might be met. There's so many interesting differences with robots. Well, really starting from cyberspace through robots, so much pressure. If you think about areas of law, like, even civil procedure and standing, how, there might be sort of a balance, and most jurisdictions have figured out how to handle jurisdiction and venue, but we're still not necessarily comfortable with it. It's been fascinating to me since the pandemic to see what seemed like would never, ever happen, which was at least some court hearings online, right? So to take advantage of that. So that, leads to a lot of kind of interesting considerations. Okay, sorry, I'm watching my time. And so now I'll go to the fourth paper, Cynthia's paper. And this also is a fantastic paper. It talks about reasonable foreseeability and legal recognition of platform algorithm facilitated emergent systemic harm to marginalized communities. So just to kind of reduce that, she talks about the different aspects, the algorithm design, business model, time and scale of the platform, and the users and the reach of the platform, and the users' human nature as all things that you would have to consider in terms of looking, trying to ascertain whether there is systemic harm from the technologies to marginalized communities, which is pretty fascinating. And she roots it in Canadian tort law, which again, it actually, it's a much longer paper, gets a pretty good, I felt like I understood a bit more after reading the paper, just even generally about Canadian tort law, which I really appreciated. And okay, so she talks a lot about foreseeability and unintended consequences. And, foreseeability too, I mean, torts is just so challenging and rewarding to teach because, you know, every time I teach foreseeability, I may actually change my mind a little bit about, you know, where the meets and bounds of it are and what it really means, and the unintended consequences aspect of all this. Of course, these aren't new, you know, issues with technology. When I was teaching at the University of South Carolina, I parked in a faculty parking lot one day. There was like a very flash rainstorm, but it was like a humongous amount of rain, like 6 inches of rain in a half an hour, some ridiculous thing. And I didn't even know, because when I got to my car, everything was dry again. It was like rain, whatever, but there'd been a flood. My faculty parking lot had filled with water. My car had been like literally submerged in water. So when I opened the door, all this mud came out. And so I tried to talk to the university, like, you know, liability, are you going to fix my car? Are you going to replace my car? Whatever. They said, no, 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 no. This was an act of God. We're not responsible for acts of God. And I said, no. I don't think it's an act of God. I don't think that God was against my car. I think that was actually an act of bad drainage was the problem, right? But we actually had a tort system in South Carolina that recognized acts of God for as a defense for something like that. So these are all choices we make. Those are choices that were made about cars. And now when we get into, you know, foreseeable and unintended consequences, I guess one thing maybe we could be discussed more if you're interested is just, is there something different here? You know, than making those kind of choices that the community is already making the kind of choices through, you know, jury verdicts and you know, judges and opinions, and then sometimes state legislation, et cetera. So common law evolves. So one thing that paper brought out for me, which actually may have meaning to the other 3 papers as well, and that is trade secrets. I don't know if you thought I was going to bring that up or not, but because every single paper, which is why these papers are so great, wants to model or think about sort of a model or a framework to address, you know, liability and technology, and, you know, through foreseeability, through different tort law constructs. And none of that can happen. I don't think anything that's proposed in any of these 4 papers can really happen, excuse me, without access to a lot of data, you know, to do the modeling, to actually see what's going on. And so what's really not addressed in most of the papers is how you're going to get that data. And I fear that the legal constructs of trade secrets will make it very hard to get a lot of the information that would enrich, or, you know, these models and help them to function most effectively. So thank you all for writing these great papers, and I look forward to your reactions and anything else you'd like to say.
Thanks so much. I guess it's my turn to jump in now. Really appreciate your comments. To ensure everyone has time, I'll limit my remarks here to sort of directly responding to what you said. Feedback was pretty narrow. Reduce the jargon. You know, less jargon's always good. Can certainly work on that. I think it's a question of who the target audience is, and I sort of had in mind institutional design literature that tends to speak in this more sort of law and economic language, but I do think there's a broader relevance here of the paper, and probably smart to go ahead and sort of eliminate some of that jargon to make it more broadly applicable to a larger group. I think your question about getting the data is absolutely on point. One of the things I sort of, or I should say a premise of this paper, is that there are a lot of different types of actors that are now looking to regulate autonomous intelligent systems, right? And these range from market actors to self-regulation to state intervention. And so those differently positioned actors are going to have access to different types of information, right? So a private sector actor looking to work up an approach to regulating technology is going to have less access, presumably, to some important information than, say, a state actor is. And so when we're thinking about trying to find the right regulatory mix of these different types of actors, which is sort of the thrust of what I'm proposing in this paper, that probably should be a more important ingredient in the framework than I currently allow for. So that point's really well taken. I know we're short on time. I've sort of directly addressed what you said. I'll give you, I'll cede my final few minutes to you, and if you have anything else you'd like to say about the paper, or I'll turn it over to the other discussants.
Yeah, actually, if anyone else had a quick comment, or I guess we'll have a Q&A later. So I believe, is it Sylvia's up next? Do I have that right?
Yes. Hi. Well, thank you to the organizers, and thank you, Anne, for reading our papers and giving us these feedbacks. It's actually very useful to me because as a civil law scholar, I actually I had the same feeling you had with all the other papers that were more based on a common law system. But I realize what you're saying. It's a very good point that if I want this to be read by a broader audience, I need to first put an explanation, or at least make the audience first more familiar with the civil law system there. And actually, my ambition is then to scale this paper into a research project where I look for, I check if these concepts can also bridge the distance between civil law and common law, so that we can have a regime that might work in between the systems due to the progressive more interconnectedness, and we might have actors from two different systems in a future tort proceeding scenario. And so I would definitely work on that to make it more palatable for a common law audience. And I second your germinal, the use of the word germinal proposal. I really like it, actually. So great. And if I may actually also address the thing about trade secrets. As a former business lawyer, I actually also often wonder how we can make things easier for a damaged party, because trade secret is going to be the main objection that that is going to be put forward. And that was actually one of the things that led me to use the qualified social contact theory from Germany and Italy, because since it's hybrid between contract and extra contractual liability or tort, the burden of proof is reversed. So the damaged party does not need to have access to those trade secrets. Is the producer or the company deploying the artificial agent that are going to have to prove that the damage, the causal connection is not there. And that was kind of my escamotage, my way to find a solution to that, but it might not work, definitely. So I will also put further thought into that. Absolutely. Thank you. Very interesting.
Okay, the Park paper.
Okay, this is KS. Thank you for your comment. Our goal was to obtain understanding of how people, not us scholars, but how people in general think about legal personhood of AI as an answer to the liability gap or punishment gap that the current legal system suffers from. I mean, you probably read the papers, and the conclusion is that people are inconsistent about legal personhood, in a sense that they generally agreed with the idea of holding AI responsible, and yet they generally disagreed with the idea of giving AI any property or any physical independence, which are the prerequisites to the idea of a liability or idea of punishment. But we thought that learning or relearning the relationship between the properties and physical independence, and on one hand, and legal liability will kind of give us an opportunity to go forward on this dilemma, so to speak. I think that there are a couple of on that front, there are a couple of questions I had on other papers. I'll just use this opportunity. On Sylvia's paper and Adam's paper, I was wondering whether your approaches are any or will be any different if the subject matter of regulation or subject matter of liability are not AI, are not robots. I think that duty of care and also regulatory system capable of generating information or self-generating information, I think both are very important components of a competent regulatory system on other things than AI. So I had a question for each of them. And on Cynthia's paper on platform, on holding platform, holding platform for emergent systemic harms, my question will be this. Now, emergent harm is the way it is defined. It cannot be tracked to any concrete action, any specific action by the system, by the platform. It can be tracked to more general, global actions of the platforms that did not have foreseeable consequences. Now, even if it's not,
maybe we can let Cynthia present, and then
okay.
more questions. It might be easier for her if she has an order she'd like to address these things. It sounds like a great question, but I'd like to let her go ahead, and then we can get back for Q&A. Cynthia?
Oh, sorry, do I go now?
Yeah.
Oh, okay. I just also turned my camera on. So thank you so much for your responses. It was, it's always very exciting and nerve-wracking to put work out there and see how people react to it. So I really appreciate your comments. Just a few things I picked out. First thing is I laughed at Law of the Horse because I definitely read those debates as well. And it's funny because I kind of ran straight into the Law of the Horse question while I was doing this paper. When I set out to do it, I thought it was going to be a platform regulation paper. I thought it'd be an intermediary liability paper because that's where I was coming to it from. But once I decided what I actually wanted to do, I started doing legal analysis. I realized, wait a second, this is basically just one out torch that I'm extending to the context of online platforms and platform algorithms. Getting to do that work and extend context and have change, which is where the idea of recalibrating reasonable foreseeability came about. I also really loved your parking lot flood analogy. This wasn't an act of God, it was an act of bad drainage, which is just such a great example that can also parallel what I talked about in the paper with respect to platform design and how so much of where legal liability comes from is a result of how those involved choose to frame what the legal problem actually is, which then speaks to questions of how do you allocate responsibility and how that allocation should be done in a normative way and not necessarily just in a descriptive way or based on how it's been allocated before. With respect to the trade secret question, this is something, so I've done some advocacy on the USMCA and all of the digital rights issues that came up with that. So things like source code review and proprietary algorithms are something I constantly come up against, and other issues too. And I had 3 thoughts with that. The first one is that I don't think it's actually necessary in all cases that we need access to the actual source code or to whatever would have been deemed proprietary. There's some work being done in the accountability AI fate showing that even if you have a black box algorithm, if you know enough inputs and the outputs, that in some thing is that even if you do need to know, or sorry, okay, another thing is that in the last part of my paper, so I specifically looked at a situation where algorithms did lead to truly emergent outcomes that were genuinely unforeseeable by anyone, regardless of social location, regardless of if you're marginalized because they were autonomous and supervised machine learning algorithms, what do you do in that case? And so the science scale approach by Yves Bataille, hopefully I didn't pronounce that too wrongly, is that the liability analysis actually moves upstream. So it's not about what the algorithm did itself. You're actually looking at the decision to use an algorithm in the first place. So I could also see cases where you wouldn't necessarily have to know what the contents of the algorithm were, because you're looking at the preceding conditions of them deciding to use the algorithm and whether they knew what was in the algorithm in the platform context to like scale employee conditions, user behavior, and things like that. Having said that, I can imagine that there definitely will still be cases where we do want to know what the actual source code is, what the actual proprietary data is. And I think in that actually, it's in the tort, if we're in the area of torts, then that's litigation. And I think that's maybe where the discovery process could be leveraged, or in the case of liability, that's where disclosure come in, where it just has to be part of that process, where in order to reach a just decision, we need to have that information. So therefore, they should be legally compelled to provide it, even if it's just on a confidential basis. And this is all in the private sector, but I've been working on a separate project to do with algorithms. And so there, I think that's something that needs to be thought about beforehand and after the fact. So we shouldn't just be thinking about algorithmic liability after the algorithms have already been built and rolled out and deployed and harm has been done. We should be thinking about algorithm liability at the beginning. Someone is considering bringing an algorithm into existence for a particular purpose. And at that case, if you can already foresee that it is for a public purpose, for example, like criminal justice, then at that point, maybe there should be conditions attached. Maybe the government, for instance, should attach procurement conditions where if we are going to use the vendor's algorithm, there has to be disclosure requirements attached. It cannot be a trade secret. It cannot be proprietary. Otherwise, we're just going to go with someone else.
Oh, hi. I think actually I'll turn over the floor to some other folks who had voiced questions earlier in the round, so we can ensure to get those questions out.
Okay, Sylvia?
Hi, yes, I'm back. Well, actually, I was curious because the question that was advanced before about would something be different in my article if there wasn't an AI, and I'm not exactly sure I understand the question. So if you could explain a little bit, and then maybe I can understand that better, because actually I was super interested in the paper about the attitude of people towards the electronic personhood proposal, and but because I was very curious of their framing, that they considered that to be inconsistent, while somehow I found a certain consistency in the answers of people, and so that paper was actually terrific, and I'm very happy that I got the chance to read that. And more than a question in my case for him would be if he could expand a little bit on the why they consider that an inconsistency. Just that, and if he can repeat the question for me, because I'm not sure I grasped it.
Okay, should I go? Hello.
I think so, yes.
Oh, okay, all right. So the question for Sylvia is duty of care, and I believe we used the term, let me see, human-centered design or human-centered legal design. It seems that the requirement of human-centered design can be applicable not just to AI, but other things, simple objects like automobiles or other products that are mass-produced. Just wondering whether this is a concept that can be generally applied to all objects that are involved in accidents, and therefore give rise to legal liability. That is the question. Now, on my request on our paper, maybe Gabriel is online as well. Maybe Gabriel can help out as well. But as I said, it does not make sense to, it is impossible to even conceptualize the idea of holding an agent liable unless the agent is capable of holding assets, because the whole system, the practice, the idea of holding an agent liable means taking away the assets from that agent. Now, if the agent does not have any assets to begin with, there is really, doesn't have assets and is not capable of holding assets, then we cannot hold that agent liable. But people think that robots should not hold assets, and yet think that AI, the robots should be held liable. In that sense, we think is inconsistent. Now, on Cynthia's paper, my question was the way, and also in response to Professor Bartol's question about trade secret, is that currently the version of AI that's being the version of AI that's being that is dominating the current world is based on machine learning, which means that the source code is not really where the power lies. It is the data. It is the training data that really decides how the source code creates any result, whether it's emergent or not. So, for instance, recently, Amazon hiring system ended up failing female applicants more than male applicants, even if they had the same qualifications. That did not come from the source code. It comes from the training data. Data can be a trade
secret also. Data itself can be trade
exactly.
secret.
I agree. I think that it is the but on that, I think that there's a lot that we can reveal without violating trade secret, because what we want is aggregate data of how, once they look at the emergent behavior, and once they find, once they see the defect, or once we see what we believe is defect, it gives us an angle to look at the data and not actually look at the data itself, but just extract aggregate parameters that are present in the training data. So that is my answer to the trade secret question. And on Cynthia's paper, again, I think that your attempt to hold systemic behavior will, I mean, it will be very difficult to work with that idea when, if there is any fault, it lies with the training data, not with the source code, and not with any action that platforms have made in deploying certain source code. You also mentioned that.
Okay, yeah, I want to give Cynthia.
I'll stop there.
Yeah, we're getting a little short on time, and I want to make sure Cynthia had a chance.
Okay.
Okay, so to raise questions, Simone. Hello?
Yeah, we can hear you.
Great. So I had one question for Adam's paper, which was, so one of the things you did to show the different costs of potential regimes, as well as the cost of the initial AI or robotic system that was being regulated, is you reduced them to, I guess, literal monetary costs. And I think I just wasn't sure how or why that was done, or necessarily what the rationalization was, or how, like, why, what would justify the eventual numbers being reached, either in the model or even just in real life, especially knowing that so many costs from these systems and from both market failures and regulatory failures are non-monetary and are really hard to reduce to financial numbers.
Yeah.
Oh, sorry, did you want me to go through all of them at once, or?
Sure, go ahead.
Okay, and then the question I have for the Park paper is mostly a clarification. So you showed that people generally think that the AI or the robot is responsible for harm, but we cannot hold them liable for lack of assets or ability to feel pain, for instance, and therefore there's a gap. But what I wasn't clear on is whether, when people are responding that they think that AI is responsible, do they just mean that in a factual sense or a conceptual sense, as in, yes, from a factual causation basis, the AI is responsible, but does that then mean that they, by extension, automatically also believe that they should therefore be held legally liable? Because I think those could be separated if that wasn't also established through the survey. And Sylvia's paper, I didn't really have a question. I just really liked it because we had an email exchange. There was just so much resonance between the two of ours. And it was great because it speaks to what you were saying, and where I obviously was rooted in a Canadian, so common law tort background. And so reading about duty of care from a civil law perspective, and especially given that I specifically excluded duty of care for mine for scope reasons. So to see someone come in and do that duty of care piece was just really nice.
Great. Okay, so Adam, did you want to respond?
Yeah, sure thing. And thanks so much for the question, Cynthia. I really appreciate it. I think what you've hit on is one of the biggest criticisms of the law and economics approach, right? Because it does look to reduce these harms down to a dollar value. I think there's a couple of, excuse me, a couple of responses. One is that use of dollars is a good way to sort of set out sort of a model of a framework, because the costs can be sort of itemized in a very discrete way, right? So whether or not there might be costs that one day can't fit into sort of an economic framework, we should at least begin the process by sort of using dollars as a way to account for the harms, because it gives us a way to sort of be able to look at these big questions in sort of discrete terms. So we can actually sort of say, you know, if a certain type of harm rises to this level, then the intervention probably wasn't worth it. Now, there's a further question of whether you can reduce all harms to dollar values, and that's obviously a super disputed question. I think probably, you know, the work that OIRA does in the US is probably the most sophisticated example of looking to translate really subtle harms around health, for instance, to dollar values. So that's sort of a tradition in the American regulatory system of looking to translate all different types of harms to dollar values, but of course, sort of agreeing that there are some types of harms that that we really can't translate and really can't capture the full value of the harm through through a dollar value. So definitely recognize that big point and agree that, you know, to the extent that there are a significant number of these harms that fall into that category, then that would be a challenge for the framework laid out here.
Does anyone else have any comments, responses?
Actually, I can respond to Sylvia's question about our paper. Thank you, Sylvia. I mean, not Sylvia, Cynthia. Cynthia, thank you very much for your question. Actually, that is something that we didn't have time to explore and include. We should have asked people who responded to the property physical independence question. We should have confronted them and asked them about the second question, but we didn't get to do that. We didn't find a correlation between responses on the same respondents on the first set of questions and second set of questions. That would have addressed your question. Thank you for your input.
If I may add one last thing, Anne, to answer to the question also was given to me. In human-centered design, I borrowed from design and computer sciences. So anything from a mouse to scissors to a software can be a design based on the concept of, well, putting the necessities and the preferences of the individuals at the center, but that does not become on itself a source of the liability. So what I do is I got inspired by that to wonder, okay, we need to put the individual at the center of the legal design here. So what are the solutions that put the individual at the center? And ideally, what I would love to do is actually something similar with what you guys did in your paper, which is one of the reasons why I really liked it. And it's actually ask the stakeholders, which can be individuals, companies producing certain softwares or robots, or even the government. What are the necessities? What are the preferences? And from there, elaborate or find possible legal solutions that also can incorporate these kinds of inputs. So the definitely human-centered design is way broader. That was a concept I borrowed.
And I just realized I also didn't get a chance to respond to Kunsin's question to me. The first thing with respect to data versus algorithms, I definitely agree with that point. And I think I would say exactly the same thing that I said earlier with respect to black box algorithms in terms of whether the data is proprietary, whether the data should be disclosed. I would apply all of that to the training data as well. In response to the question about how you can hold the platform liable for systemic harm if there's no one specific action you can pin it on, that was kind of the whole point of my paper, was to investigate how can we do this. The first thing is that I would say a lot of what we think are emergent systemic harms, I showed in my paper, were not in fact emergent. And if you look through, whether it's through media leaks or employee revelations, you could find one specific point or actor where you could pinpoint it, either because they knew what was happening and didn't act, for example, or they knew from the start, where it's genuinely unknown and it was kind of an unaccepted sum of being the greater of its parts. I think that's actually where the idea of looking at things on the aggregate comes in, where I wanted to make clear that I wasn't just writing another paper on individual harm. I didn't care if one user was harmed or one user was abused on the platform, where I did. There's evidence, say 500 users have been harmed and they all happen to belong to a particular vulnerable demographic group, then at that point, should you consider that the platform has been on notice? And then that's where the other factors come in. And if they did know, should you have considered that they should have done something about it, which is then where something like standard of care could come in, for example.
Perfect.
Great, Florian, there, great.
Yeah, thank you so much. So usually this is the moment where we will hand it over, like we will go to the audience for their own questions. Sadly, we cannot do this, but I invite everybody who has been watching that video recording to share their ideas, their thoughts, their comments in the comments section below. And on that note, I would like to thank you, Anne, for making the time to be the discussant, to reading those papers. Some of them have long titles, but they're also very long papers. So thank you so much, and for sharing your thoughts. And of course, to our authors for submitting those great papers and for being with us today. Thank you so much.
Thank you.
Thank you so much.